Namaste and welcome to a brief overview of share capital. We will go through this topic in four heads: capital and rights, premium and discount, issue of shares, and change in capital. Under capital and rights, we will start from section 43, share capital, get into voting rights. Then we will also deal with equity with differential rights, and section 48, variation of shareholder rights. Then we will deal with the two heads of securities premium account and shares issued at a discount. And our interest will take us to further issue of capital, sweat equity, bonus shares, employee stock options, and global deposit receipt. And to end with, we will go into alteration of capital, reduction of capital, buyback of shares, and cases where there is a prohibition on buyback. This is a overall view of our scheme of things. This is part A, and in part A we will cover capital rights, that is share capital, voting rights, equity with differential rights, and variation of shareholder rights. Please refer part B and part C for premium and discount, issue of shares, and change in capital. Let us get into the first part of share capital under section 43. Share capital of a company limited by shares. It says share means a share in the share capital of the company, and it includes stock. The share capital of a company limited by shares will be of two kinds: equity share capital and preference share capital. Equity share capital can be of two types: with voting rights and with differential rights. This is as to dividend, voting, or otherwise. Now we talked of it includes stocks. Stocks is a generic term. When you talk of a chunk of shares belonging to different companies, you refer to stocks, or shares of a company consolidated into different lots, that is called a stock, whereas shares refer to ownership of a specific company in specific lots of sizes and face values. If you go by the definition as given in the Act, equity share capital is one which is not preference share capital. That forces us to see what is preference share capital defined as. Preference share capital is one which has preferential right as to two things: as to dividend, which can be a fixed amount or it can be calculated at a fixed rate. And so far as the repayment of capital is concerned, there is a preferential right, and it may have a preferential right for payment of any fixed premium specified in the memorandum or articles. A share which carries preference in terms of dividend and repayment of capital is preference capital. If we go further, share capital divided into two, equity and capital. Equity can be with voting or differential voting. Preference has got essentially one privilege with it, preference as to dividend and preference as to repayment. There is also a provision which says in addition to this, they might have a right to participate with equity holders in dividend and also in surplus on winding up. Just to see the specifics. Capital which shall be deemed to be preference capital, it is entitled to either or both. In addition to preferential rights as to dividend, it has a right to participate, whether fully or to a limited extent, along with the share capital in repayment on winding up. It has a right to participate in any surplus which may remain after the entire capital has been repaid. Now, this is what we are referring to. Now, this is the overall scheme of equity capital, preference capital, mandatory preferential rights, and possibility of an additional right along with the equity holders to share with the dividend at the end and also to have a share in the surplus. That is up to the share capital under section 43. Now we will go to voting rights under section 47. Equity shareholders have got a right to vote on every resolution placed before a company, and the voting right of an equity shareholder on a poll shall be in proportion to the paid up equity capital that he has. And a preference shareholder, he will have voting right to touch only those resolutions which directly affect his rights. If something doesn't affect his rights directly, he doesn't have voting right on that resolution. Means voting is used to protect your rights, be it in the normal course or on winding up. Therefore, the resolutions which interest a preference shareholder are three. One which directly affects his rights. Second, on any resolution on winding up because it affects his rights. And on any resolution which involves repayment or reduction of other parties, including equity shareholders and preference shareholders. Because when the money of the company is used to repay other creditors or other parties, that affects the rights of a preference shareholder, and hence he also has got a right to vote on resolutions which involve repayment or reduction. Once again, his voting right will be in proportion to the paid up amount vis-a-vis the paid up preference share capital of the company. Now, this is regarding what a member as an equity holder has got a right to vote on every resolution, and preference shareholder has got a right to vote on resolutions which affect his rights. And there is a special case where dividend in respect of, say, preference shares or a class of it has not been paid for 2 years or more. That preference shareholder will have a right to vote on all resolutions placed before the meeting. Means his rights are affected deeply. Therefore, to protect that, he is entrusted with the powers to vote on all resolutions placed before the company. This is a special situation where the preference shareholder gets a right to vote on all resolutions. Once again, the number of votes or the value of votes depends upon, once again, the proportion of paid up capital on those shares vis-a-vis the total paid up capital of their class. It may be equity shares or it may be preference shares. And between equity and preference, once again the ratio is paid up capital of equity versus paid up capital of preference. Just to take an example, if 10 lakh rupees is the paid up capital of preference and 100 lakhs is the paid up capital of equity, then the ratio of votes will be preference 10, equity will be 100. That is how the votes will be cast. That takes us to the equity with the differential rights, DVRs, differential voting rights, under Rule 4 of the company's share capital and debentures rules 2014. Let me look at it. Differential rights as to dividend, voting or otherwise, generally known as the DVR shares. Now, to issue an equity share with a differential right, there are certain essentials. Essentials are as to the articles has to provide for it. The issue has to be authorized by an ordinary resolution. And in case of a listed company, the requirement goes to that of postal ballot resolution. And when you issue those shares, the voting power of those who have voting rights, which are differential, should not exceed 74% of the total voting power. Because every share has got a voting power, and a share may be with differential voting or without voting power at all. Now, when the differential voting power held by a share, if you consider only differential voting shares, their volume should not exceed more than 74% of the total voting power. And since this is a special type of shares which is being issued, this is a privilege. Not every company can issue it, and therefore what is insisted upon is when you issue an equity share with only dividend right and no voting rights, it becomes some sort of a share with dividend as an assured income. To assure that income, it has to be seen that the company which issues a DVR has to have a track record of consistent profits for the last 3 years. This is the compliance requirement in respect of the DVRs. Let's go ahead with it. When a company wants to issue these shares, we have seen it should have consistent profit record, and there is the requirement coming here. It says they should not have defaulted in filing financial statements and annual returns for last 3 financial years. And there should be no default on declared dividend payments, no default on repayment of matured deposits, and anything which is due for redemption in preference or debentures, it should have been paid on time, and all payment of interest on such deposits and debentures or dividend should have been timely done. We are talking of financial discipline in terms of payment of dividend, repayment of debentures, preference shares, and repayment of deposits and interest thereon. And once again, this is regarding the subsisting default in payment. And it also says the company has not defaulted in payment of dividend on preference shares or any term loan taken from a public financial institution or bank, or interest payable thereon, or any PF, ESI, certain statutory payments. There should be absolutely no default, and sometimes the amount of unclaimed dividend has to be transferred to Investor Education and Protection Fund. All these payments should have been done by the company without any default. These qualifications are essential to ensure that the company which issues shares with the differential rights has got firm discipline and financial strength to meet its commitments on time, both in the past and in future, and there are no statutory defaults or term loan defaults. And if at all a default is there under any of these heads, under EFG, what the rules state is, these could be waived only after expiry of 5 years. For example, if a company defaults in the year 2006 till 2010 and it cannot issue differential rights as to dividend, because we have to await expiry of 5 years from the last default. And once 5 years are a clean period, then we can proceed to issue equity shares with differential rights. And there is one more requirement in respect of the company, that the company should not have been penalized by the court or tribunal for the last 3 years under any of these acts of SEBI, Securities Contract Act, or FEMA, and there must be no punishment on the court in terms of penalty for offenses. In the sense, what the act states is, equity with differential rights can be issued by only companies which are quite disciplined and which have sound financials, and that is where this repayment discipline and penalizing by the court or tribunal is resuming importance. Just to have a look at the thing, article should provide resolution has to be there, or it should be through a postal ballot. It cannot exceed 74% of the total voting power. Distributable profit should be there for 3 years in terms of its filing, payment, repayment, and court penalty. It should be a clean company before it issues a differential rights shares. And when we say we need a resolution to be passed or postal ballot to be passed, any passing of resolution has to be preceded by a notice to be sent to shareholders. And this is where the Act very clearly says, if you are sending a notice to the shareholders as an explanatory statement to the notice under section 102 or under section 110 explanatory statement to the postal ballot thing, it should contain specific details about the entire scheme of things. The explanatory statement has to say what is the total shares, what are the differential rights, what is the percentage of shares with differential rights to total post issue, reasons for issuing the shares, at what price, what is the basis. This is to have more of transparency than anything else. And if it is in case of a private placement of the same thing or preferential issue of the shares, the explanatory statement should state how many number of shares have been allotted to promoters or directors or key managerial personnel, and what is the balance shares given to persons other than promoters, and what is the relationship with any of the promoter groups. And in case of public issue, what are the different classes of applicants, including promoters, directors, and key managerial personnel. The whole idea is here to ensure that the differential vote right shares are clearly identified as to the holders, so that it becomes more transparent and more visible in terms of who is concentrating voting power of the company. This has to be within the knowledge of the shareholders when they receive the notice of notice with explanatory statement or explanatory statement for the postal ballot. And once again, the requirement continues in terms of the percentage of voting rights carried by the differential voting shares, how the terms vary between one with the differential voting right, one without differential voting rights, and with the issue of this size, what is the impact on the control and management of the company. And once you issue these shares, the earning per share will vary. What is the diluted earning per share? And after the issue, which is proposed to be done under the proposal, what will be the new shareholding pattern? How does it differ from the existing shareholding pattern? Means the explanatory statement has to explain very clearly the process of issue of these shares, and it should also deal with what is going to be the consequence in terms of the control of the company and in terms of the earnings per share and the shareholding pattern. And an explanatory statement with these details will keep us fully posted on the composition of the shares, its concentration in different groups, and then what is its consequence, composition, consequence, and also the numerical particulars of the entire proposal. And we also have other requirements. See, when you send a explanatory statement, it should also be reflected in the director's report for the year. Same details will appear in the director's report. If we can be specific, what are the total shares, details of differential rights, percentage of differential rights, price at which it is issued, shares issued to promoters, change in the control, diluted earnings, pre and post issue shareholding pattern. These are all appearing in the explanatory statement. Whatever is indicated to the shareholders, it should also form a part of the board of directors report for the financial year as a proceeding. And it also states there are a few additional requirements. This process of issuing differential rights is a new portion of shares. It cannot involve existing rights to be converted into shares carrying differential voting rights. It has to be a new bunch of shares issued by the company. It cannot be taken to empower the existing shareholding. It has to remain as it is. And in case of differential shareholders who might not have voting right, but they will have other rights like bonus and right shares on par with the other equity holders, means the differentiation is largely as to dividend and voting. Means what? Dividend may be slightly higher than normal and voting may be nil. They might not have any voting powers in the meetings. And the register of members shall contain particulars equally for both, for shareholders with the differential rights and shareholders with normal or additional rights. Now this is as to the requirements of the board report contents and the other essential requirements as to you can't convert an existing share, and the shareholders of differential voting will be eligible for all other facilities except for variation in dividend and voting, and register of members will record things on same pattern as the normal shareholding people. share capital, voting rights, equity with differential rights, and that takes us to variation of shareholders' right. Can the shareholders' rights be varied? Variation could be done. The rights attached to shareholders of any class may be varied. But once again, it is a matter of special resolution. It has to be consented by not less than 3/4 of the class of shares by means of a special resolution. Not less than 3/4 means when the votes are cast against the resolution, number of votes in favor should be 3 times or more than the number of votes cast against it. 3:1. That is 75%. And for variation of shareholder rights, first we should see that there is an enabling provision in the memorandum or articles. And if there are many class of shares and we are varying one particular class, say A, and this is remotely connected with a class called C, we are taking consent of class A and altering their rights. But if it is connected with another class of shares and its rights are also affected, then it is also required that we should get their consent with a voting of not less than 3/4 of the holders of it. In the sense, any variation, directly or indirectly, if it is done by the company, even when it is provided by memorandum or articles, a special resolution with 75% consent of votes cast has to be there in case of one company which is directly affected, one group, and other groups of shareholders who may be remotely affected by this, they also should consent to make the resolution or make the change valid. Then, even after this resolution is passed, if some shareholders say we don't want to accept this, and if their number is not less than 10%, there are two requirements. One, they should not have voted in favor of the resolution. Number two, their size has to be not less than 10% of the group of that particular shareholders. They can move the tribunal to have the variation cancelled, and that movement application has to be made within 21 days. Once the resolution is passed here, people who have not voted, if they constitute, or people who have voted against, if they constitute not less than 10% of the voting power of that class, they can approach the tribunal, company law tribunal, and that application has to be put within 21 days. And where such application is made, even when the resolution is passed, it is kept in abeyance. It will not be implemented until the decision of the tribunal is made. We have to await the decision of the tribunal after hearing. And the decision, when made, will be binding on all the shareholders. And once the decision of the tribunal is come, the company will file it with the ROC, a copy of the order, and take it on record within 30 days. And in respect of variation of shareholders' right, company has got a major responsibility, and therefore it has to ensure that there is no default, because if there is a default, company and its officer will have penalties and criminal punishments involved, and that is the reason. And even besides that, company has to follow the procedure and carry out the due process of law. This is the provision regarding the consent of 3/4, passing the resolution as a special resolution, And if it affects other consent of other class, we have to obtain it. If someone is not agreeing with the contents, then he can move the tribunal. We have to await tribunal's decision till such time the resolution will not have any effect. Once decision comes, it is binding on all shareholders, and the company will file with ROC within 30 days. Company has to take care that is perfect compliance so that it doesn't affect or it doesn't attract the penal provisions of the Act, both as a company and for the defaulting officer. We have covered capital and rights in part A video. Please refer part B and part C for premium and discount, issue of shares, and change in capital. Thank you so much.